Up. All right, well, welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel. I'm joined by Judge Edwards and Judge Grosshands today on the panel. And first up, we will have O'Hare versus State of Florida, 19-12-95. And counsel for the appellant, if you'll just let us know how much time you want in rebuttal so we can set the clock.
Yes, Your Honor. I'll take 5 minutes in rebuttal.
All right, very good. You may proceed whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Joseph Zwick and I represent the appellant, Robert O'Hare. After the trial court denied Mr. O'Hare's dispositive motion to suppress and found that inevitable discovery applied and it was an exception to the exclusionary rule, he entered a plea and was sentenced to 20 years in prison. Mr. O'Hare appealed the denial of the motion to suppress, and this court remanded the case. This is a very unique factual scenario where the applicability of the exclusionary rule was fully litigated in the first motion to suppress hearing. All of the issues were raised. The trial court was silent regarding independent source doctrine and found that inevitable discovery applied. The case went to the 5th DCA and a separate panel, I don't believe any of you were on that particular panel, remanded the case back to the trial court with instructions to make findings regarding independent source. On remand, we had the motion to suppress hearing again.
Counsel, are you asking us to revisit the decision of the prior panel?
Not necessarily, but it's a unique factual scenario where
wouldn't we essentially have to reverse the prior panel's instructions?
Yes, essentially my position in this case is that instead of remanding it back for the same argument to be had, this court should have basically did what the dissent in Murray did on the independent source doctrine, and found that because the trial court had all of the issues before him and did not make any findings regarding independent source, that rather than just ignoring that subject altogether, having it been presented, he determined that didn't apply and there weren't factual findings. Instead, this court sent it back.
Counsel, I think that's an appropriate motion for rehearing to that panel. I don't know that that's something that this panel can do necessarily. I think we understand your arguments on collateral estoppel. So I want to ask you about the independent source doctrine specifically. Are you familiar with US v. Segura, or Segura v. US?
Yes.
Okay. How would you distinguish this case from that one?
This case is different from Segura primarily because in Segura, the evidence that was illegally obtained was first discovered during the legal search. There was 2 searches. The first time they went in, they found in plain view a large number of drugs. And on the second time, they didn't find any new evidence that wasn't already discovered during the legal search. So the legal search didn't reveal the new evidence. In Murray, and I believe this case is much more similar to Murray than Segura, the actual illegal evidence was discovered during the illegal search. There's no way to separate the illegal search from a legal search. And that's how I would distinguish Segura from applying in this particular case. Regarding, go ahead.
Do you think there's any issues in your case regarding in Murray, there's a break. So the officers go in, they see the marijuana, they leave, no one knows they're there. Then using completely separate information, they get a warrant, they go back, marijuana is still there. So the actual illegal entry really didn't affect anything in the case. Do you think that's similar to your case here, or how would you say that that's different?
I think the facts of this case are worse as far as the Fourth Amendment goes than Murray, because here you have an illegal search. There's no disputing the illegal search. The same officer that was involved in the illegal search was there in the home for over an hour, leaves and applies for the search warrant. There is no break at all. In Murray, you had, I think, almost 24 hours before they actually got the warrant after they did the illegal search. But here, it all happened in the same event. And so in order to find the, as Luna from the 4th DCA, the clear and unequivocal break between the illegal search and the legal search, there is no way to do that. The dissenting opinion in Murray, which obviously isn't the law of the land, but I think that really identifies how strongly this situation is, where the dissent would have reversed immediately because there's no way to separate the idea of an illegal search where the officers completely violate.
There was no separation in Segura, correct?
In Segura, there was separation. There was two different searches. The earlier
No,
search,
the officers were in the apartment the entire time, the way I read the opinion. Am I missing something in there?
well, you're correct. There was different. I guess the big difference is that the same officer that was involved in the illegal search was not actually the one who went and got the search warrant in that case. There was an illegal entry, and they basically squatted in the home until they got a warrant, and they found additional evidence during the second search when they had the warrant than they did in the first. And so our big argument came down to when they first seized this big apartment building, did they seize the entire thing so that it would cover the entire building for what would be considered suppressible?
Wouldn't you agree that Segura kind of forecloses this temporal break argument that if there's no temporal break, that alone amounts to a violation of the Constitution, right?
I can understand that. The temporal break, certainly it wouldn't be dispositive in a case. I think it's definitely a factually, every situation has to be looked at on its facts. And ultimately the exclusionary rule is designed to prescribe police misconduct. And ultimately, under the rule, if independent source doctrine applies in this case, there is absolutely nothing stopping law enforcement who has probable cause.
The way it's been interpreted, I would maybe rephrase that, or at least ask you if it should be rephrased. The way that it's been interpreted by the courts is to make sure that officers are in no better position than they otherwise would have been due to misconduct. Would you agree with that?
Yes, the Nixon case says that, and it's also designed to be a remedial measure to prevent, essentially keep from giving an incentive for law enforcement to do what they did in this case. So if the independent source doctrine applies in this case, and if you have probable cause that evidence may be in a home, why bother getting the search warrant first? Just go
Answer that question here, counsel. Do you agree the officers could have, instead of walking up and essentially just storming into the house, for lack of a better way to describe it, you agree they could have just gone and gotten the warrant, right?
It appears that way. There's no fact. The Judge Hill and the second motions press makes findings that there was probable cause to get a warrant beforehand. It's interesting because in Murray they remanded the case.
Do you agree that there was probable cause beforehand?
It's not to make an arrest. I don't believe so, because ultimately
for the search,
not at the house, because the big difference and the opinion by Judge Hill, I don't believe is supported by any competent substantial findings. He essentially affirmed the DCA in making his findings. He's literally quoted the 5th DCA's opinion. I can't hear Judge Edwards if he was talking.
There you go. They saw him on different occasions at this cafe. They have pictures even. They took photographs of the Toshiba laptop. They saw him with his computer bag. And on the day they went to his house, they saw him leave the cafe with the computer bag. So, I mean, it's not like they were taking a real long shot. There was no certainty that the laptop was in the computer bag, but there was certainly a reasonable basis for believing that. And if you look at the affidavit for the search warrant, about the only information that's added to it is that they went to the house and he wouldn't let them in. I mean, that's the only thing that they really add in the search warrant, isn't it?
That's the only thing added. I do believe that is relevant, because it's essentially, if the police believe that they could have gotten a warrant without going in and having an illegal search, why didn't they? What we have on the record is that they didn't, because the reason they didn't do it is because they weren't sure that the Toshiba was going to be in the house. So they wanted to go ahead and confirm first.
Let me ask you this. Do you think for this situation, the standard that should be applied as to the officers where they have gotten the warrant, is that an objective? Do we look at that objectively, as in, is there a probable cause for a warrant? Or do we look at the subjective intent of that officer? For instance, did that officer think he could have gotten a warrant and he did the illegal search anyway? What do you think the case law supports on which way we look at that?
It's hard to say one way or the other specifically, like for every case, because I think every case is different. On Murray, the remand was specifically to go and find out if they would have gotten a warrant prior hand. So that's kind of the same situation right here, is would they have done it? On the record, if they could have done it, it seemed that would have been the logical solution versus breaking into someone's home and creating an illegal search. If you look at the record on it,
counsel, the other option is when the detective showed up at his house, they thought perhaps he would let them in and let them search. They were wrong, but that's just as reasonable as thinking they're going to have to force their way in. And if they were able to go in there consensually, why do they need to go get a search warrant?
Oh, and that's one option. That even after the officer was in the home and knew that consent was off the table, completely could have left. However, he stayed at the residence for over an hour to find the laptop. If it was so important to find the laptop at the home, I believe the record indicates that it was not going to be a search warrant situation where they believed they could have gotten a warrant. Otherwise, there's no practical reason to confirm the laptop is there unless they really
did they believe they couldn't get the warrant, or did they just not care to get the warrant?
It's hard to say. There's no findings on the record to support either way, which in this case, if there's nothing on the record, I don't believe that this court could find that independent source applies, because the findings that were made after it was sent back were essentially just, kind of taking the 50 ECA's lead on remand and saying, we'll just try it again. That's on record page 927. Judge Hill literally says, try it again. We'll see what happens. And so all of these issues were raised at the first hearing. Judge Briggs picked one that didn't work. And then Judge Hill was like, okay, well, we'll try the other one. If there was a third exception to the exclusionary rule and the 50 ECA recommended it to the trial court, they would probably pick that next. But there was no new findings.
Counsel, the state did bring this up in the first hearing. This wasn't completely out of left field. They did bring it up. It was argued. It just wasn't ruled on. So that's why it was sent back. I have a question for you though, factually. Was your client allowed access to his possessions after the illegal entry?
No.
And is that your argument regarding that there was no break, that there was this illegal search and then we went straight to getting a warrant?
I mean, that's kind of what happened in Segura, and that's, that wasn't, what the Segura case found to be an important factor. I think, whether or not he had access to, he was basically arrested as soon as they said he resisted the illegal search. They charged him with resisting without violence. Law enforcement spent so much time trying to find this Toshiba. I just don't believe that it actually it's supportable to believe that if law enforcement believed they could have just left and got a warrant, we have to assume they just had no idea what the law is in order to justify staying in the house for an hour to confirm what they're looking for, then to go get the warrant. If this is independent source, there's nothing stopping law enforcement who believes that they have probable cause to search somebody or something from going and just making sure first, just to do a kind of a dry run.
Counsel, whether this court agrees with the U.S. Supreme Court's Segura opinion or not, it's kind of irrelevant. How is that conclusion not already decided in Segura? I'm unclear on how you distinguish that case.
So Segura from this case.
Correct.
In Segura, when they went in with a warrant, there was evidence that was discovered that was not previously discovered. That is true here, but the laptop was discovered during the illegal search. So in Segura, the reason that I believe that was acceptable is that majority of the evidence, if not all of the evidence that was used as evidence to charge Ms. Segura in that case, was found during the legal search of the building. The illegal search was a small area and like one apartment room.
I think I understand what you're saying now. So you're saying that in Segura, officers conducted an illegal search of the apartment, but it was unsuccessful in finding the drugs.
Correct.
Therefore, because the officer's illegal search in this case was successful in finding the laptop, then that is the way you distinguish the two?
Yes, there's no way to separate. Once you've already gone in and confirmed, how do you separate going back in and with a warrant and finding the same thing?
Counsel, I mean, in Segura, they knew they were looking for cocaine. I mean, you know, that's exactly what they were going in for, right?
Right. They didn't find it in the apartment they were illegally broke into with Segura. They found it in the rest of the building.
So if officers in this case had stormed into the home, searched for the Toshiba laptop, but were incompetent in their search and were unable to find it, then when it did exactly what they did, stayed in the apartment, got the warrant, came back, and on the second search, they were able to find it, you would say then this case is indistinguishable from Segura.
I would. But in this particular case, you can't distinguish it because they went in there to find the Toshiba. They broke into a bedroom to find the Toshiba. There's conversations about, oh, we found it. Then they go get the warrant. And so the trial court's findings regarding independent source don't cover all of the issues that you would need under Murray to even determine that the law enforcement would have gotten a warrant prior, or that they had any intention of getting a warrant prior. The record on its face shows that they had no intention of getting a warrant until after they confirmed that the Toshiba was actually in the house, and that's what they did. And if the Fourth Amendment allows a dry run illegal search of a person's home prior to using the warrant, that certainly seems to fly in the face of the exclusionary rule. And I would reserve the rest of my time for the rebuttal.
Okay, thank you, counsel. All right. And counsel for the state, whenever you're ready.
May it please the court, my name is Chris Davenport and I represent the state of Florida. There is testimony about what their intent was.
Counsel, why did officers, how would you describe the entry here? Would you say they stormed in, or how would you describe it?
I would not describe it as storming in. I would describe it as a knock and talk that went a little bad.
No, it wasn't a knock and talk, was it, counsel?
It started out that way, and when he said no, things kind of went bad.
Right. So what would you describe it after the knock and talk ended? How would you describe this?
I would describe it as an illegal protective sweep. When you look at why the trial court originally found that this was not valid consent, he said no, and then the police said, well, is anybody here? And
this wasn't just an illegal protective sweep. This was an illegal entry. Like, they should, in theory, they pushed their way into the house and then did a protective sweep. So in all ways, I think you have to admit, once they left that front, once he put his foot in the door, we have issues with the entry. Would you?
Yes, I would agree that this was not the best entry.
Counsel,
he stuck his foot in the door.
It was a forced entry, correct?
Well, he stuck his foot in the door. It's not like they kicked the door down, but he stuck his foot in the door, which you're not allowed to do.
I didn't say they kicked the door down. I asked if it was a forced entry, yes or no?
I wouldn't call it a forced entry. I would call it an improper entry, but you know, we're talking semantics here. He should not have gone in the house.
Counsel, does Segura allow law enforcement to simply ignore the warrant requirement so long and to force their way into a house, stay there for potentially hours until they then obtain a valid warrant that they could have obtained to begin with?
Segura and all of these independent source cases don't apply the exclusionary rule where there is a truly independent basis for how they got the evidence. And that's what we have here. So the police officers are allowed to secure the property until the warrant is served. So there's nothing improper about them staying there.
There's nothing improper, counsel. I thought you just said there was something illegal about what happened here.
The sweep was illegal. Forcing their way into the house was illegal. Staying there and securing it is totally appropriate while they get a warrant. They can do that so that the evidence isn't destroyed.
How can they do that?
So the state's argument is you can illegally enter because you think you might be able to get a warrant, which you haven't even started applying for yet. So you're going to illegally enter, you're going to find the evidence, and then you're going to sit on it until you get the warrant that was required to begin with.
The state's argument is that this was an independent source, a proper warrant. They went in front of a magistrate, a neutral and detached judge who said, yes, you can go search that house. You have probable cause. That's how they got it. All of the stuff that happened at the house beforehand was improper. We can't get it in that way. We can't have them testify we saw the Toshiba in the house that way. All of that was improper. The question is, are we going to put the police in a worse position because they did something stupid here?
But how do we know that the laptop, I mean, this is not Murray. We had bales of marijuana. They illegally went and looked at them, snuck back out. Apparently no one even knew they were there. So very, secret. And then they went and got the warrant. Turns out nothing had happened to the warehouse in the meantime. Then they went in, the marijuana is still there. That is very different from what we have here, in which we have, I mean, there's nothing to say the police would have found the laptop if they had waited for the warrant and not gone in to begin with. Correct?
No, that's not correct. The police found the laptop while they were doing their sweep. They didn't put that in the affidavit for the warrant. They didn't mention that. That was not like they were.
Still been there.
I'm sorry?
I mean, how do we know it would have still been there? If they hadn't.
We don't need to know that. We need to have probable cause that it would have been in there. They saw him with this black computer bag. They took pictures of the bag. They saw him that day with the bag. They saw him take the bag into the house. That's probable cause that the computer that he was using to share child pornography was in the house. That's what the magistrate found.
Counsel, your opposing counsel argues that, look, these officers, they needed to find the Toshiba laptop before they wanted to apply for the warrant. What evidence would you rely on to suggest that the officers intended to get the warrant before their illegal entry into the home?
Well, first of all, we're not arguing inevitable discovery. We've already lost that. And to win on that, we would have had to show that they were in the process of getting a warrant when they went into the home. This is a totally different exception. Independent source has nothing to do with that.
Counsel argues that they would not have sought the warrant without confirming that the Toshiba laptop was in the home, which I think would eliminate your independent source argument if true. What evidence is there, if any, below that officers would have obtained the warrant regardless of the illegal entry?
We have the testimony of Detective Hart at the first suppression hearing. They asked him, when things went bad right away, they went and did the knock and talk. The defendant said, no, you can't come in, and no, I don't consent to search. And the officers immediately said, okay, well then we're gonna go get a warrant and we're gonna secure you while we do that. Detective Hart testified at the first suppression hearing that they had probable cause before they went there, and they were trying to make it easier. It's easier to get consent than to go get a warrant. That's why they did it that way. He testified to that. And then that's clear by what they say on the body camera. Well, then we're going to go get a warrant and we're going to secure you while we do that. So clearly it was their intent to do that.
Counsel, where's the clear and unequivocal break between the illegal search and the legal search?
I don't think that that's the focus of this particular test. It's not about whether or not there's a break. It's about whether or not there's an independent source.
On page 17 of your brief, you say appellee would point out that a clear and unequivocal break is required for it to be untainted, and it's voluntary only if it's untainted. Well, what's that discussion all about if it doesn't have anything to do with this search?
If that's in our brief, then that's a mistake, Your Honor. When you look at Rodriguez, they talk about 3 exceptions to the exclusionary rule. They talk about inevitable discovery, independent source, and attenuation. And attenuation is where you focus on whether or not there's a break. And that's things like, rereading Miranda 2 hours later and all the fruit of the poisonous tree. discussions in the case law. Independent source has nothing to do with a break. You don't need a temporal break. What you need is an independent source. That is the break. The fact that you got the evidence completely independently from the illegality, that's the break right there. It's not about time, it's about source. So it's a completely different kind of exception to the exclusionary rule.
In terms of whether the police or the deputies knew the computer was going to be there, they didn't have to know with absolute certainty that it was going to be there, did they?
Absolutely not. They just needed to have probable cause. And again, the defense did not challenge the sufficiency of the probable cause for the warrant below. They never argued it wasn't sufficient. And when you read the affidavit, which is in the record on appeal, there's absolutely no mention that they found the computer in that house illegally. That there's no mention of that at all because they didn't need to do that. They saw him carrying the computer bag into the house. That's probable cause that the computer is in there. Plus you have all the case law saying that we know how pornographers keep their stuff in the privacy of their home because it's illegal to have it. So that's where they keep it. There's a lot of law on that as well. So they had probable cause.
I want to go back to something you said, which was they need to have been able to get the evidence completely independent of the illegal search. And I guess that's where I'm a little bit kind of hung up on this issue of they went in illegally and guarded the property until the warrant came. So I don't quite understand the assurance that you're giving us that just because they could have had probable cause to go in, that their illegal entry did not assist them in obtaining the evidence because they were able to sit on it for what appears to be hours in between the time they illegally entered and they got the warrant.
Well, first of all, it's only an hour. It's not a bunch of hours. According to the testimony, it took them about an hour to get the warrant.
Okay, go ahead.
The only thing sitting there did was prevent the defendant from destroying the evidence. He doesn't have a constitutional right to do that. They can secure a house when they're going to get a warrant. Now, the way they, the search of the house, the protective sweep of the house was improper, but it was all right for them to secure the house while they went and got it, just to prevent the destruction of evidence. So the only illegality was that they saw the computer in there. That wasn't mentioned in the warrant. It wasn't part of the probable cause, and they didn't need it. He doesn't have a right to destroy the evidence. We can't assume that that's what would have happened. I mean, independent of them going to the house at all, they could have just taken the harder road and gone and gotten a warrant, which, as it turned out, would have been the easier road since he wasn't going to consent to search. A lot of people do, so they knock and see if the guy will let them in. But isn't
that, if the Constitution means something, when officers decide to try the easy road and do the knock and talk and get consent and it doesn't work, aren't they kind of taking the chance that then they're going to have to go get a warrant without, violating the Constitution and forcing their way in to conduct an illegal search? Isn't that kind of a decision they made?
The improper decision they made wasn't knocking on the door to see if he'd consent.
No, I'm not suggesting that was improper. No. I'm not suggesting that was improper. I'm saying they made the decision to take the risk that he would say no.
Right.
And the Constitution doesn't allow them, when he says no, to say, oh, well, we're coming in anyway and we're going to force our way in. Right?
Right.
And it's always easier. It's always going to be easier for law enforcement to ignore the Constitution, right, counsel?
Of course it is.
Yeah. So what's the deterrent here? If law enforcement can do what happened here and there's no constitutional violation, no ramifications, what is the deterrent for law enforcement to just do this in every single case?
Again, they had the right to secure the property.
No.
What they did wrong.
What they did here, they did far more than just secure the property. What is to stop law enforcement from doing what they did here every single time?
I don't think there is anything to stop them, and there shouldn't be, because they got it properly with a warrant independently.
You've already agreed they violated the Constitution.
Yeah, and we can't use the evidence that we obtained by violating the Constitution, but the Supreme Court has made it clear that we can use the evidence we obtained independently and properly through a warrant that was independent of anything they saw in that house.
So it's your position that the law as it currently stands allows officers to do this exact thing every single time, and there are no ramifications for it.
If they obtain a warrant legally and independently, yes, because they shouldn't be put in a worse position because they did something stupid and illegal. They can't be worse off because of that. That's what those United States Supreme Court cases say. That's not what the exclusionary rule is about. Society has an interest in properly obtained evidence, and we have properly obtained evidence here. It's not easy to show an independent source. I mean, if they would have needed to see the laptop in there and they got in there and that's how they got it, that wouldn't have been, then you could challenge the probable cause here. If they had never seen that black computer bag and they were speculating that the laptop was in the house, and they busted in there and confirmed that, and they put that in the warrant, that's not a good warrant then. So everything, the warrant dotted its I's and crossed its T's. That's how we got the warrant. That's how we got the evidence, is through serving the warrant and searching pursuant to that. And the Supreme Court is making crystal clear that as long as that's independent, which it was here, nothing from the illegal search was included in that warrant except for the fact that he didn't cooperate. And that had nothing to do with probable cause.
Certainly this court can't disagree with the U.S. Supreme Court. That is very clear. And I do think Segura is probably your best case. Are there any other cases like Segura, or is that sort of an outlier?
No, I think that the third DCA case, Ojeda, O-J-E-D-A, I think it's very similar facts. They had an illegal entry into the house and an illegal protective sweep. But then they went back and smelled marijuana when the defendant opened the door, and that enough was sufficient to get a warrant. And that was completely independent.
I may be misremembering the cases or mixing them together, but didn't law enforcement leave the property entirely in that case?
They did. I'm not positive about that. They might have. But again, that temporal break has nothing to do with this independent source thing, unless that's where the independency came from. Here, the independent source was a warrant, which is the best independent source you're going to get, because that's what we want police officers to do, is to go get a warrant. And that's what they did here. Now, they did something improper before that, but that can't put them in a worse position than if they hadn't.
Do you agree that if we read Segura the way you suggest, and I think it's certainly a fair reading to read it that way. I'm not saying it's unreasonable, but if we read it that way, would you agree that Segura essentially makes the constitutional warrant requirement a post-search warrant requirement?
No, I don't agree with that.
Well,
because
isn't that what happened here?
That's what happened here, but
and you said
again,
you said that essentially this can happen in every case, right?
It can, as long as there's an independent source, sure. But they could sue the police. There are other deterrents for conduct like this. They can sue the police for busting into their house. I mean, there's all sorts of civil consequences. The police could be disciplined. The question is, are we going to apply the exclusionary rule? And that's a pretty extreme sanction. It takes away key evidence from a criminal that needs to be taken off the street. Society has an interest in us having that evidence, but we do the exclusionary rule. This is an exception to the exclusionary rule. So that's why it's here, is because you can't put the police in a worse position because of that. As long as they got the evidence legitimately, which they did, then you look at the other sanctions for the impropriety versus society being punished by taking away this valid evidence that they found pursuant to a perfectly good warrant. So that's my answer to that. Yeah, they can do this every time. I would think that they would eventually get drummed out for doing this every time, because it's not proper what they're doing. And, hopefully police officers are told to quit doing things that are improper. The question here is the application of the exclusionary rule.
Telling them to stop doing improper things if they get their guy in the end. I mean, isn't that a pretty big incentive for the police?
It is. So there's a balancing here, but it's pretty important for society to have, a valid warrant, that we get evidence of a serious crime like this, that's admissible at trial. That's important too. So by balancing the two, what the Supreme Court has said is we're only going to apply the exclusionary rule if these exceptions don't come in, the inevitable discovery, the attenuation, and the independent source. And in this case, we do have an exception. It clearly applies here. And that balancing weighs in favor of society in this case. The evidence comes in. That doesn't mean that those police officers didn't have consequence for going in the house like that. Based on the mother's actions toward the police, I would imagine something else happened to them. I'm not sure. There's nothing on the record, but she was mad. So hopefully that's dealt with in other areas. The question before this court is the application of the exclusionary rule and the exception to that for an independent source, not how do we keep police officers from doing this. There are other methods for doing that. And the exclusionary rule is not the only thing that controls them. And it's pretty clear how the exclusionary rule works in this context. So given all that, we would ask the court to affirm the lower court's order. Thank you.
Thank you, counsel. All right, and counsel for the appellant, it looks like you have 3 minutes and 53 seconds whenever you're ready.
Thank you. Murray talked about motivation and whether or not, law enforcement would have gone and got a warrant had they not gone and confirmed what they were looking for. I believe that suppressing this evidence in this case is consistent with Murray's application, because based on the record, the best evidence we have of what the law enforcement's motivation is or was is what they did. They say that they talk about getting a warrant, they talk about getting consent, but at the end of the day, they stayed there for over an hour, confirmed what they were looking for, and then went and gotten a warrant. If this court upholds this behavior, there is no Fourth Amendment. There really isn't, because all you have to do is, once you have probable cause, just stop there, and then you can go do whatever you want.
Do we have the right to overrule the U.S. Supreme Court? I mean, Segura seems to be pretty much on point here.
I don't believe this would be overruling the Supreme Court. In Segura, the evidence that was challenged was evidence that was found in a second legal search warrant. There was a separation between what was found the first time and the second time. Because the law enforcement decided to go and find everything illegally inside my client's home, there is no separation, because there was nothing new to find when they got the warrant.
But there was an independent source that predated the illegal search. They saw your client at the cafe during times when porn was being downloaded or shared, at times with the Toshiba laptop. They saw the black bag. They followed him home. I mean, they could have, with that basis, and nobody challenged the sufficiency of the probable cause affidavit. They had probable cause to go in at that point in time. They just chose to do the knock and talk instead. But they had that independent source before they got their search warrant to go and get a search warrant, didn't they?
As far as the probable cause, the courts have indicated that wasn't raised as an argument. However, under Murray, why would they have remanded the case back to determine whether or not the law enforcement had planned on getting a warrant prior to the search if that wasn't a requirement? But the state has pretty much made it clear that as long as a warrant is obtained, it doesn't matter what law enforcement does to anybody in their own home, as long as they can go get a warrant afterwards. And I don't believe that was ever the Fourth Amendment that I learned in law school, or that any of you have been practicing with.
Do you think Segura is distinguishable in any way because they had already applied for the warrant prior to entry versus a case in which like Murray was after, and then this case I believe is after?
I believe that's a huge distinction. And then Murray, which came 4 years after Segura, remanded it back to basically find out if there was any efforts to get the warrant prior to the illegal search. In Segura, at least they were trying. It was illegal what they did.
Counsel,
and there
wouldn't
was,
we have to conclude that there was no substantial competent evidence below that the officers would have applied for the warrant absent the search, the illegal search?
it's not just substantial competent evidence that they would have. The state had the burden of proving by clear and convincing evidence that an exclusionary rule exception applied. And that's the state's argument that we just heard, that it doesn't matter.
The trial court found in the state's favor, right?
The second time, after basically just affirming the.
So aren't we looking for
opinion.
substantial competent evidence to support that ruling by the trial court?
I don't believe that is what the DCA is looking for. However, saying, hey, let's send this back and try it again, I don't believe is anything new than what happened the first time. There was no new evidence presented, and the results should be the same as it needs to be suppressed.
Thank you, counsel. All right, we will be in recess until 10 o'clock.
Thank you.